All right. It's 2 o'clock on January 12th, 2026. This is the Rules Committee of the Superior Court's January meeting. It is being streamed live on YouTube. In addition to being conducted over the branch's Teams platform. In attendance, I'm seeing on the screen Judge Aaron, Judge Armata, Judge Doyle, Judge Green, Judge Griffin, Judge Mazurowski, Judge Torres, and Judge Welch. So I believe we have everybody on the committee present. All right. So with that out of the way, we'll take up the first item on the agenda today, which is the approval of the minutes from the December 15th, 2025 meeting of the Rules Committee that was provided to all members. Is there a motion?
I'll make a motion.
Judge Doyle moves for the approval of the minutes. Is there a second?
Second.
Was that Judge Aaron?
Judge Aaron.
Yep, thanks. All right, any discussion? All right, all those in favor signify by raising your hand. Any opposed? Any abstentions? All right, Judge Mazurowski abstains. The minutes are approved. The next item on the agenda is 2023-011. This is a proposal for a requirement that attorneys who use AI programs verify the accuracy of the citations therein. There was a proposal which I had drafted based on our prior conversations and my conversations with the AI committee. That goes a little bit beyond just legal research. It relates to using the generative AI for research and verifying the accuracies of both the facts and the legal citations and the quotations contained therein. Basically recognizing that AI will get used, is currently used for more than just legal research and will be used more extensively as time goes on, I'm fairly certain. So that was the idea behind the proposal. I will tell you that there is a new chair of the AI committee, Justice Ecker. I forwarded the proposal to him about a week ago, got responses from him late in the day or in the evening, Friday night. He is generally supportive of the approach taken, had some suggested language tweaks to it, which I'm going to go over with Lori and Legal Services. But before doing that, I wanted to see what comments I had from everybody on the committee as to whether we should be, this is the right approach, we should be taking a different approach, we should be asking for input from any other interested parties. So I'll just throw it open for discussion.
Thank you for calling the Judicial Branch Technology Helpline.
Justice Brett, I have a question. It looks really good, and I am no kind of AI specialist. So let me say that, give my disclaimer up front. What was the significance in 4-9?
Hey, Reese, this is Judge Armata. I'm calling from my courtroom. On the Rules Committee, I cannot hear anything going on.
Barry, we can hear you.
Yep.
Figured Barry was checking up on me.
So, Judge Armata, I don't know if yours shows where your audio is coming in from. He can't hear us, so telling him this will be of no value, I just realized. So if, Lori, if you could reach out to Judge Armata.
Yep. Well, what would you like me to tell them?
Sometimes whether, I don't know if he can figure out where his audio is coming from. Let me just try sending him something in the chat.
Lori, I could try to communicate with him and give him the dial-in information if you want.
Okay, that'd be great.
Yeah, that would be good.
Okay.
We'll give Judge Armand try to set it up that way.
Can you hear me, folks?
Yes, can you hear us?
I apologize. I couldn't hear any of you, and I had IT on the phone and they couldn't fix the problem, but apparently they did.
Okay, all right. So we were discussing 2023-11, which is the proposal for a certification for AI. And Judge Doyle, you were had a comment / question.
Thank you. So in 4-9A, the last line that talks about in similar commercial technology, Bill, was there a reason to phrase it that way as opposed to something like any similar technology that is capable of creating such content? I was just wondering what the distinction about commercial technology is and seeing how everything's going to be changing over time. Was there some reason for that?
No, that was language that was included in the Kansas model.
Okay.
And I just thought it was broad enough to pick up anybody who is selling a generative AI product. I suppose there is a question if it's not a commercial AI product, if it was some other created through some other mechanism. I guess we could do it some other way. So alternative language on that is I think entirely fine, and not something that I was tied to any particular language.
Yeah, no, I mean, otherwise I thought it was good. I was just more for myself if there was some meaning in this field to commercial as opposed to, you know, something that what may not be considered commercial in terms of how fast this is being developed.
Justice Bright, if I may.
Yeah, Judge Welch.
Thanks. So just I have one word that I thought we may not need, but then I had a subparagraph or from our last meeting that I don't know if we want to address. So in subparagraph B, the second to last line, it says, or third to last, I understand that the failure to do so may result in court-imposed sanctions, including the possible entry of non-suit or default judgment. I would probably eliminate the word possible because we always say may result in court-imposed sanctions, including the entry of non-suit or default judgment. That would just be part of the certification or my comment to that. The second, I think we talked about it at the last meeting, was those people, not in a written memorandum, but during the course of oral argument, relying upon AI in whether it's in response or in part of their argument. So I didn't know if we wanted a subparagraph E that in any representation to the court in which a party uses AI, the party shall so advise the court and indicate that they have, and then use the same language, independently verify the accuracy of the information. Something along that, because I think someone here had mentioned that, and I've noticed people looking at their phones during some hearings, and if they're checking or trying to Google something. So I know we're taking care of the filing requirements, but maybe in the same paragraph, adding something if there's a representation made to the court that relies upon AI.
Sure. The one difficulty with doing that in this rule is this is in the pleading section of the rules, section 4. So there are other parts of the rules that relate to oral argument. And I think that's a good suggestion, and we can look at incorporating these same comments that we would put in 4.9 as the pleadings in other sections relating to oral argument. So we can, unless anyone disagrees, we can look at incorporating that elsewhere. Okay, I'm seeing nods of heads, so that we'll undertake that further review. Any other comments? Questions? Judge Griffin.
Yeah, I think one comment or concern that I still have is regarding the utility of the certification. You know, it looks like, looking at the rule, it says that it's required on all documents filed. So one concern I have as an aside is whether that also includes judicial branch forms, because I'm certainly in the family law section. Most of our filings are on judicial branch forms, which I don't think immunize them from the use of AI, because often people will just write "see attached" and they'll just stick a sheet of paper next to it. But do we need to have this now on, if it's all documents, is that going to be everything that's filed? Does that include the appearance form? Does it include more routine forms where there's likely not to be used with AI? So I have a scope question there. Additionally, it looks like the clerk's office is not going to be reviewing every document to ensure compliance before accepting the filing, which I understand why that would be an administrative nightmare. But if that's the case, the concern I have is that the folks who are going to stick this certification on are going to be the people who are complying with the rules, because they're going to know that the rule is there, they're going to be diligent, and they're going to put it on there. And most of the parties who don't know about this and haven't been told they must do it in order to file it probably aren't going to stick the certification on there and may not even become aware of the rule. So what I'm concerned about is that the certification just becomes a burden for parties who are following the rules anyway, and might itself do little to actually help enforce the underlying rule, which I think that we're trying to get to, which is I think that people are responsible for any content they put in their documents, AI or otherwise.
So let me take each of those in turn. The judicial branch forms have actually had some conversation with Lori about that. And I think we'll need to talk to court ops about how we do that. Certainly forms that do not allow for elaboration, I probably think you don't need to have that certification, like an appearance form. But an answer, for example, in a housing case, which is a pre-printed form, but allows people to fill in whatever they want to fill in, or as you point out, attach, those we do want to capture, I think. So it's a matter of finding that right balance and maybe working with the language of the rules to make it clear what it doesn't apply to. So that's a good point, and we'll have to figure that out. As to the second point, we often run into this issue. It's certainly, I remember a similar discussion occurring when we adopted the mandatory continuing legal education rule. The thought being that the people, because it's a self-certifying process, the people who are already doing CLE and we don't need the rule for it, they're going to certify it, and the people who aren't doing it, they're never going to pay attention to it anyway. And how do we know? The hope is that it becomes prophylactic and that the lawyers should know that they have to do this. The Appellate Rules Advisory Committee is working on a similar obligation that would apply to counsel's filings and also self-represented party filings. And I think that some of what we may see in terms of the people relying on AI when they shouldn't is people not knowing that AI creates hallucinations or inaccuracies. And I'm hoping the primary service the certification provides is alerting people to that danger and not being a way of sanctioning people or punishing them for not complying. So I'm open to other ways of doing it. I'm just not sure how else we get at that.
I wonder if the certification is sort of ancillary to what we're trying to accomplish with the rule, maybe the way the rule is drafted should be flipped a little bit, because it looks like a lot of the impetus is that this is a rule requiring an extra certification. And then we explain why we need the certification. And even if you don't do it, we're deeming that you've read the rule and you understand why the certification is needed. Maybe it should be flipped a little bit. Maybe the rule should be, we need to put a rule together that says you're responsible for what goes into your pleadings, including your AI. And you need to be aware of the use of it and the like. And then say, and parties must then certify that they understand the rule and the like. But that's one thing that I noted reading it, is there wasn't really sort of an affirmative statement of a rule that the parties are responsible for the content of their filings, even if generated by AI, given the concerns. So that was one thought.
Sure. All right. We'll take that into account in looking at it as we fill in some of these other gaps. Anybody else have any thoughts? Judge Armada.
Hope everybody can hear me now. So this has been on the boards since 2023. And the problem was trying to grapple and get our arms around it. And some states that had started rules said they were too restrictive, and they they suddenly changed and they had to undo what they did. I think this is a good first step, and this is a rule that's going to be organic, and we're going to see how technology and the courts interface, and this rule is probably going to need to change over time. But I think to acknowledge that, look, you're responsible to ensure the accuracy of what you're filing, and understand that if you don't, the court can take action in terms of preclusion or default or something like that. So I think it's a good first step. I agree with Judge Welch in terms of oral presentations. I'm seeing that in the family court where people have got a phone and the next thing you know, they're listening to arguments and coming off that. That's not a pleading, but I think should be maybe a duty to alert the court that I'm using it.
Okay. Anybody else? Judge Green.
I just wanted to, my thought on it is that I know that we've been working on this rule for a long time, and the more familiar, I'm not an expert on AI by any stretch of the imagination, but I mean, it seems to me, my understanding is that the hallucinations and the difficulties with AI are sort of inherent in that, and that's probably not going to change given the nature of the technology. I think that the rule that we're starting with does sensitize folks to the fact that the charm of AI is that it seems competent and fluent, that it knows exactly what it's talking about. And I think that a lot of folks don't know that it doesn't. And to Judge Griffin's point, I mean, thinking about family court, I mean, I would certainly want to know if somebody was assisted in putting together a restraining order application or an ex parte custody application using AI. So, I mean, I think that while the technology is certainly transforming and evolving, that I think we kind of proactively should say something with what we know now, because people mistake being sure, sounding like you're sure about something, as being accurate. And I think that is certainly not the case.
Okay. Anybody else have anything? So here's I don't want to exclude anyone from the process. At the same time, I'm happy to continue to work with Lori and Jill and James to incorporate some of the suggestions or all the suggestions you all have made, as well as talk to Justice Ecker about whatever suggestions he has. If you are all comfortable with me doing that as kind of a committee of one, I'm happy to do it. If others would like to be involved, I'm happy to hear if people would like to set up a committee.
I'm happy to help you in any way you need. And just talking about the timing, whatever we come up with in terms of a product, we're going to have to send it out to stakeholders like the CBA and Trial Lawyers Association for comment.
So that was one of the questions I had. Although we anticipate additional revisions to this proposal, should we send this proposal out now, given where we are in the year and given if we want to get something approved this year, we're running short on time. We basically have 2 more meetings after this one to get it done. So we could, if you would like to, send it out to the CBA, the CTLA, the CDLA. I don't know if there are other groups that anyone thinks we should be sending it out to.
Would you
Yes,
like
Lori.
to also have court operations comment on it?
Yes. Yep. But
I'd probably send it to the CAJs too, just for comment, so they know it's coming.
okay.
It seems like sooner would be better, just because they may have even a better understanding of the potential of how it's being used out in the field already. So it might be good to get input from them.
Okay. All right. So does somebody want to make a motion for referrals?
I'll make the motion.
All right. So Judge Doyle makes a motion to refer it to, would that be CBA, CTLA, CDLA, Court Operations, and the CAJs?
And I would
sounds
probably
good.
add
we
statewide
miss
legal
anything?
services.
All right. Judge Armada suggested adding statewide legal services. Is that okay with you, Judge Doyle?
Yes.
Okay. Is there a second?
Second.
Judge Armada seconded. Any further discussion on the referrals? All right, all those in favor signify by raising your hand. Any opposed? Any abstentions? Okay, the referrals will be made, and in the meantime, while those referrals are being made, I'll work with Lori, James, and Jill on a revision that we'll have presented to you at the February meeting. Okay.
And Justice Bright, before,
Lori?
I'm sorry, I was just gonna ask you, a very picky question. Is Judge Armada's role, is there gonna be like a referral to the judicial branch's AI committee? Or, you know, I know Judge Armada is on the committee. Do you want a separate referral or?
Well, I don't think a separate referral will be necessary, only because I've communicated with Justice Ecker, and I think Justice Ecker will take it up with the committee at their next meeting. I think everybody except Justice Ecker had been from that committee, had received a copy of the proposal, and I think it was consistent with the prior discussions I had with that committee. But I'd rather just if we need to have it formally referred to Justice Ecker and the AI committee, I think we can do that. I don't know that it's necessary given the discussions that I'm having with him.
Okay, sounds good.
Okay.
Thank you.
Okay. All right. Anybody else have anything? And I'll just, in the interest of not burdening everybody here and just kind of keep it moving along, I'll take the lead in doing this. If anybody has any thoughts, please feel free to reach out to me. Please let me know what you want to do, what you would want included. If you want to look at something as I'm going through the process of revising it, just let me know. Okay.
and Justice Bright, I just was looking for a point of information as to that separate committee that Judge Armada is on. So there is a committee that was formed by the Judicial Department that is tasked with what is that task?
Judge Armada, do you want to answer that?
Yeah, I don't have my notes with me, but we were given discrete functions to look at the use of AI in the judicial branch, how it can help folks, how it can promote efficiencies, problems. It was chaired initially by Justice Alexander, and then the meetings, when things changed for her, the meeting sort of went offline. I don't think that we have anything scheduled. Justice Eckert's just being named as the new chair, but it was that committee created the idea, and I met with Justice Bright, Justice Alexander, and others to say, you know, we need to do something in terms of a rule amendment to sort of encapsulate what we've been talking about, and that started sort of the genesis of this drafting.
Great, thank
There's
you.
another big part of that committee's work which does not, at least right now, intersect with our committee, and that is what should the internal rules be for the branch in terms of employees, branch employees, and judges using AI. And that, as I said, I don't think will intersect with what we do as a rules committee, but that's a large part of their work. And Massachusetts just came out with rules put out by their Supreme Court on how their judges and staff should use AI.
Great. Thank you very much.
All right. Anything else on AI that anyone wants to discuss now? Okay. All right. So we will continue to have 2023-014 float with 2023-11. It's really just an informational docket listing. So we have all the information that impacts how we are drafting these rules. All right, the next item on the agenda is 2024-009, which is the review of propriety of ex parte communications with opposing parties and expert witnesses. Judge Aaron, do you want to respond on that?
Sure. I believe everyone has by now seen and reviewed the draft of the new or the amended section 13-4 experts. I think I mentioned at our last meeting that we formed essentially 3 subcommittees, one civil, one for family, and one for juvenile. And in each of those groups had members. I think the civil committee was chaired by Tom Rushin, and Judge Pearson was on that, and Sarah Russell and Glenn Coffin, and family had a number of other individuals, and we circulated this. And I think the only change from the new edition of subsection F and the relettering of the statute is the addition that Justice Bright mentioned last time to include the word retained. So there's a new provision that says, unless otherwise ordered by the judicial authority for good cause shown, a party shall not contact an expert retained and disclosed by another party under subsection B without written consent of the party who retained and disclosed the expert and written notice to all other parties. And then there's the commentary to that, which makes it clear what it is intended to do. And I think there was a comment from the Family Law Subcommittee that is included in the last sentence of that commentary, which says that nothing in these revisions is intended to prohibit the issuance of a subpoena for the deposition of another party's expert witness. So I think it's pretty straightforward, and happy to answer any questions or thoughts.
Does anyone have any questions for Judge Aaron or any comments on the proposal?
I do, with respect
Judge
to
Torres?
juvenile, I did have a chance to look through it, and I'm still, I wasn't sure what the juvenile group had decided, but I'm a little concerned that it's kind of inconsistent with our practice book sections with court-ordered evaluations. Was that discussed, and how did that get, or what resolutions were presented?
Well, it was discussed, and I think Judge Wynn also had that same concern, and that's why there really is no conflict between this section and 34A-21, because this just talks about retained experts, not court-appointed evaluators. So this section only references those experts that are retained by a party. And so it really doesn't apply to any court-ordered experts.
Well, my concern also lies with the definition of an expert in juvenile. That's why I was wondering if is going to be an exclusion as to juvenile so that we don't have an issue with that. Meaning scan evaluators, those individuals that do forensic evaluations for sexual abuse cases. If there's a definition that says retained, then one party could easily retain that person and call them an expert, thereby preventing the other party from having access to that person. That's where some of the concern when I was looking through it, like I could see somebody perhaps not intentionally, but strategically doing that so that we'd preclude another party from having access to that. So I'm a little, I just raised some concerns with respect to that.
Judge Wynn?
Judge Wynn, did you have something you wanted to add, or?
I did, thank you. So I'm looking at the court-ordered evaluators, which is 34A-21, specifically subsection E, 3, and 4. So someone who starts as a court-ordered evaluator can then later be identified as an expert. So to Judge Torres's point, if and when someone identifies that court-ordered evaluator, once that evaluation is received back to the court as an expert, subsection E, 3, and 4 are procedures with regards to the ex parte communication of that court-ordered evaluator. So if someone submits that the evaluator is now going to be an expert, are we relying on subsection E, 3, and 4, or are we reverting to what's now in the language in the practice book section that's being proposed, 13-4? So that's where I think that inconsistency could happen.
So I guess one of the questions that I have is, 13-4 is in the procedures in civil matters. In juvenile, do you ever refer to the expert procedures in section 13?
Yes, the section 13-4 is one of the practice book procedures that applies equally in juvenile court.
We could certainly just exclude that, but I thought that, actually, Judge Wynn and I thought we had discussed it at the last meeting when we were, I don't know if Judge Torres was at the last meeting, but I thought that we addressed that concern because D and, well, C, 34A-21 refers to, in subsection B, the judicial authority shall select and appoint an evaluator qualified, and it goes on. And at the time of the appointment of any, and it seems to me that court 34A-21 is titled court ordered evaluations, which would take that, I think, section entirely out of sub 13-4 when this specifically refers to experts retained by the other party. I mean, I certainly have no objection if you want to add a sentence, but I don't know how the two would be in conflict.
So let me suggest one thing that we could do is similar to what we did with the rule for, which we're going to get to, for depositions by self-represented parties. We put in some language in that rule that made reference to the rules in family, criminal, and juvenile, so that it was clear that those rules would still apply. We could do something similar here by cross-referencing 34A-21. I don't know that we've gotten any requests from any other divisions that some coordinating language would be necessary. Judge Aaron, have we?
No.
Okay.
Judge Ballas, the only comment we received a comment from Judge Diana that was simply said, well done. And Judge Ballas's email simply said that she reached out to the civil judges. And the only feedback she received was positive and they support the proposal.
Your Honors, I hate to interrupt. My name's Sarah Russell. I'm from the CTLA, and I was on one of the subcommittees and or the working group on this issue. And I just wanted to mention that we did include retained and disclosed under subsection B of 13.4 to limit it to under Rule 13. So it only applies to those experts disclosed under that section in a hopes of not having to contemplate any other parts of the practice book. So I don't know if that helps,
Correct.
but I wanted to point it out.
Thank you.
I mean, I still see in juvenile court when our trial management conferences are held that the party that's going to call the court-ordered evaluator is disclosing them as an expert for trial. So I still see that practice in 13-4 being used in juvenile court, even with court-ordered evaluators.
So let me ask you, Judge, when in that circumstance, is the party actually retaining the court-appointed expert, or are they just calling the court-appointed expert?
I think they are retaining because they have to pay the court, or they have to pay who was once the court-ordered evaluator. The evaluation is paid by the Department of Children and Families, but whoever is calling the expert, I believe, has to pay for their expert testimony.
Are they also paying for their time to prep them?
Yes.
So then would it work if we had some language in subsection F that provided that the procedures that what is in subsection F would not would be subject to the procedures in 34-21?
My apologies, I have construction outside my window.
What I was saying is, would it work if subsection F said that the requirements in that subsection were subject to 34-21?
I would be fine with that. I would be fine with that because then it would be limited to court-ordered evaluators that are later disclosed as experts, whether or not, and I'm speaking, as CHA for the judicial branch, I don't know whether or not this was brought to the public defenders, Renee Semino, who oversees all of the contracted attorneys, or the Attorney General's office, what they would weigh in, because 34A-21 has been set for, and that's been in existence for quite some time now. So I don't know if anyone else would need to weigh in on that.
Any thoughts? Anybody?
Should the rule exclude its applicability to experts appointed pursuant to that section?
That would be one way it could be done. But there are other circumstances where a court can appoint an expert witness. In some cases, the court can, in civil cases, have a court-appointed appraiser or a court-appointed evaluator that goes through and determine which of the experts' analyses are more persuasive. I wouldn't expect in any of those circumstances that the court-appointed person would be retained by one of the parties, because that would defeat the purpose of the court appointment. But it sounds like juvenile may be different in that regard. Judge Aaron?
I don't know. My experience, which is certainly more limited than Judge Wynn's and Judge Torres, who was a former Assistant Attorney General, is that generally the court-appointed expert is paid by, I believe it's by OCPD or the court. And I don't think that people then go outside and retain that expert. Generally, the court-appointed experts are disclosed by one side or the other, but I didn't think that they were actually independently retained by either side. That's just not been my experience, but I could stand corrected, and I'm happy to confer or talk to Renee Semino about it, or the Assistant Attorney General's office. I mean, this has been out there for quite some time. This is the first I'm hearing that was an issue, but I'm happy to take it to them and see if there's a problem.
Attorney Greenbacker, Jillian, did you have something?
I did. Thank you. Would it be helpful if there was an exclusion to witnesses that could be considered fact witnesses? In some of the child cases, I remember for the AG's office, that appointed experts and the interviewers that you mentioned, Judge Torres, are essentially dual. They're fact witnesses and they're experts. Could there be some sort of carve out for that?
I would be a little bit concerned about a carve out for fact and expert witnesses, because oftentimes in a personal injury case, a medical malpractice case, you may have someone who is both a fact witness and a retained expert. So I would be careful about making that carve out. I think a smaller carve out that was limited to the extent necessary for juvenile might be the best way to go here, because I'm not hearing anything that raises a concern for any of the other divisions. So I'm going to put this issue aside just for a moment, because I want to see if there's any other issues anybody else has, so that if Judge Aaron is going to go back and look at, and her committee's going to look at, or working group's going to look at this juvenile issue, if there's anything else anybody thinks that her committee should be looking at.
So Justice Bright, as I'm reading section B, the judicial authority shall select and appoint an evaluator qualified to conduct such assessments with the input of the parties. All expenses related to the court-ordered evaluation shall be the responsibility of the petitioner. However, the party calling the evaluator to testify will bear the expenses of the evaluator related to the testifying. I don't think that changes it from it being a court-appointed evaluator. that's not independently retained. Generally, my experience in juvenile court is if somebody wants to challenge the court-appointed evaluator, they would then go to OCPD and seek funds to retain their own expert. But I don't think that the court ordered evaluation would fall within the definition of a retained expert that's disclosed, a retained and disclosed expert that is hired by one party or the other. But again, if others feel that we should take it to OCPD or the AAG's office, that's fine as well.
Well, they do disclose them as experts, whoever chooses to utilize them. So they do meet that definition. So if we're
Yes.
looking blankly, they meet that definition
But
of
they're
the
not
statute.
retaining them.
Well,
They don't retain them.
they're paying them. So
Yeah,
to
but
some
paying is different than retained.
Exactly.
You can have a court rule that says who has to pay someone. That's different than them being retained, which is why I asked the question of whether they will, if they designate the person to testify as an expert, do they have access to that person prior to the hearing to prep them and get them to do? And if they have that, that looks more like they're being retained then because they are being, but that's not what 34A21 subsection B says. It just places the
And-
responsibility for paying for the testimony.
And to your point, Justice Bright, Section E then goes on to define essentially what happens after the evaluation has been completed and filed with the court, and counsel may communicate with the evaluator, and then it goes on the conditions of that communication and what they have to do. So I think it's pretty clearly spelled out. I mean, perhaps in the commentary, when we could add another sentence to the commentary that, for juvenile cases, this is the section that would be followed for court-appointed evaluators. But I don't think there's a conflict with 13-4.
So as we've discussed in the past, the only concern about the commentary is the commentary doesn't typically stay in the rule for more than a year unless we specifically ask that it stay in the rule. And perhaps just makes it clear if there's a concern among our colleagues in the juvenile division and including the CAJ that if we make an explicit reference to 34A21 in the rule. But why don't we, let me ask everyone else. How would you like to proceed? Would you like to see the Judge Aaron's working group talk with Judge Nguyen and try to figure out if we need to do anything on 34A-21? Does anyone want to just go forward with it? Are there other concerns or other questions anyone has? Nobody? All right. In the absence of anything, then I'm going to ask Judge Aaron and her group to confer with Judge Nguyen and see if there is some other final tweak we can make to this to hopefully vote on it at the February meeting. Okay? We'll go with that. Thank you, Judge Aaron. Thank you, Judge Nguyen and Judge Torres. Okay. Let's go get back to my agenda here. All right. The next item on the agenda is 2025-009. This is the proposal to amend Practice Book Section 7-19 to specify that a self-represented litigant can subpoena witnesses to depositions. There is a new version of that that was meant to address the concerns raised at the last meeting about the interplay of that section with the similar sections in the other divisions. Everyone should have had a chance to review it. Is there anybody who would like to discuss it? Okay, nobody. Is there a proposal? Is there a motion then?
I move to send it to public hearing.
Judge Welch, is there a second?
Second.
Judge Griffin. Any further discussion? All those in favor, raise your hand. Any opposed? Any abstentions? All right, it'll be sent to public hearing. Thank you.
Just one note, Justice Bright. I
Yes.
think that although the committee doesn't vote on the commentary, I think Attorney Greenbacker will be tweaking the commentary that was previously submitted as item H to conform to the proposal, which is in item K.
Okay, thank you. Thanks for letting us
Okay.
know. Does anybody have any concerns with that? Seeing none? Okay. My agenda. The next item on the agenda is a 2025-011, which is a proposal for a new rule concerning notifications to clients when a lawyer leaves a law firm. We have comments from the Connecticut Bar Association that have been received. Does anyone have any thing they would like to discuss regarding this proposal?
Justice Bright, Attorney Stovall is available on the call if you have any questions for her.
Sure. Attorney Stovall, did you have anything that you wanted to add?
Good afternoon. No, I would just point out, I don't know if people have had, if the members of the committee have had a chance to read the CBA submission, but it's essentially the CBA opposes the proposal based on a recommendation from the Ethics Committee, that the proposal is both, the proposed rule is both is not only unnecessary, but would probably likely to create more problems than it's intended to solve. I'm happy to address any of those issues if anybody wants to hear more.
So this has been on our agenda for a few meetings now. Is there anybody that wants to make a motion regarding this?
Justice Bright, I guess
Yes.
I'm not sure the appropriate way to word it, but I think I would move to not move forward with this proposal.
I'd
All right,
second it.
All right, so why don't we take that as a motion to remove it from our agenda? And who seconded that?
I did, Justice Bright. Kevin
Oh,
Doyle.
Judge Doyle. Okay. Any discussion?
Justice Price, yes. So looking at Attorney Slack's memo, or his email, where he talks about a possible modification of 2-227 parens D and parens to require attorneys to report whether they maintain malpractice insurance on their annual registration.
That's a different rule, I think. That's a different proposal. We're not there yet.
Okay, gotcha. Thank you.
I just want to make a
Go ahead, Judge
comment.
Armato.
Yeah, I want to thank the CBA for being diligent in getting us their thoughts on this. I really appreciate the turnaround and the depth you put into it. I just want to say thanks.
On behalf of the CBA, thank you for that.
All right, any further discussion? All right, so the motion that has been seconded is to remove the matter from our future agendas. All those in favor, raise your hand. Any opposed? Any abstentions? All right, the matter will be removed from future agenda.
Thank you.
Thank you. And now we're on to 2025-014, which is a proposal to require professional liability insurance for attorneys. There are the proposal that was submitted was the proposal to require it. And we did receive some information from both statewide Bar Council and from the CBA saying that because of the diverse nature of their membership, they were not going to take a position, which is entirely understandable. Judge Welch, did you have something you wanted to comment on here?
Yeah, I was just going to follow up. I apologize for that, jumping the gun there, that Attorney
That's okay.
Slacks, where he indicated that it may not be feasible to mandate, but at least the reporting requirements. And if we were going to start a working group on that, I would certainly be happy to volunteer for that.
I think a working group might be a good idea. This is a pretty significant undertaking. I think it can go a few different ways. One would be a requirement that they have malpractice insurance. And I think there's a very good question as if that's going to be required, whether that's done through a rule of the Rules Committee or by legislation. There is another way to go, which is to have people report whether they don't have malpractice insurance. A third way would be to say you have to disclose to prospective clients if you have below a certain level of malpractice insurance or no malpractice insurance. I'm not sure what that level would be, but that would be a way for at least prospective clients to know before they retain someone whether they have that level of malpractice insurance. Attorney Russell, I see you had your hand up.
Yes, I just wanted to let your honors know that the CTLA would like to comment on this, whether it's as part of a working group or as a substantive comments. We've done some research on the issue. So I just wanted your honors to know we'd love to help with that consideration.
Okay, thank you.
Justice Bray, sorry to interrupt. I just want you to know that Statewide Bar Counsel Christopher Slack is available on this call if you had any questions or wanted him to address any of his comments.
Sure, Attorney Slack. If you're there, I had this last suggestion that I had just thrown out as a possibility. I didn't know if you had any particular reaction to that, of having it just be a requirement that if you don't have malpractice insurance or below a certain level, you have to disclose that to prospective clients.
Yes, Your Honor. I do have a couple of thoughts on that. And I think as an initial matter, that would be something that my office would support. I know that when we took this to the Statewide Grievance Committee, there was no opposition to having such a either a mandate or this type of intermediate step of having it reported. In fact, there were a couple of attorneys on the Statewide Grievance Committee who didn't realize it was not already a mandate for having a certain amount of malpractice coverage. So I think there would be support on that. I think a minimum amount is preferable to no amount, just checking yes or no on the box, only because it avoids the problem of having a de minimis amount that really doesn't provide any support to either the client or the attorney. And that's what, back from decades ago when I was doing private practice, doing some malpractice defense work, the benefit was as much to the client as it was to the attorney who would gain the benefit of having a defense counsel appointed for him. That's one of the things that surprises me, is when I see attorneys in grievance matters who are attempting to represent themselves runs into that same problem. The only potential issues I see at this stage is setting what that minimum amount might be. And that would certainly be something for our working group, because obviously what is a reasonable minimum in Fairfield County might be different from what it is in Windham County, or what it is for a high-end M&A attorney or a high-end trust and estates attorney versus a general practitioner. Obviously, there would be things to take into account. And then finally, the only real pushback I see on this was whether it would be viewed as a barrier to entry for a young attorney who wants to hang out their own shingle, or for attorneys, leaving a firm and setting up their own, something like that. So I think those are issues that might have to be dealt with at some point. But I do think that this would find support, certainly in the Bar Counsel's office and from the Statewide Grievance Committee. And I believe Attorney Staines, who contributed on the comments we submitted, would agree with that as well.
Okay, thank you. Does anyone have any questions for Attorney Slack, or any further comments or thoughts on this issue? So Judge Welch, since you volunteered, we'll make you head of the working group. Would anyone else be interested in working with Judge Welch on this working group?
I'll help him if
Judge
nobody
Armada?
else is signing up.
Yeah, Judge Armada. Okay, thank you. And Judge Green. All right, thank you. So we'll have that working group. And we'll just ask, we'll put it on the agenda for February. Not that we expect there to be any proposal, but just you can provide us with an update in February, and then again in March at our meetings. And as with all working groups, feel free to cast as wide a net as you want. You had CTLA has done some research on this subject and is offering to help out, and CDLA may have similar thoughts on it. And certainly Attorney Slack and Attorney Staines may be of help to you as you go through that process. Lori, was there something that you?
I see that there's a hand up from Emily Gianquinto.
Oh, hi, Emily.
Hi, Justice Bright. I just wanted to say the CBA would certainly be interested in having a representative on that working group.
Okay, Mary, even though it's an awkward position for the CBA in some regards, so.
We have a lot of very interested constituencies, but we would at least like to participate in it.
Okay, sure. Thank you. All right, so this is, like I said, there's a number of interesting questions here. What's the best forum for imposing some requirement? And then, as Attorney Slack said, what's that requirement look like? And is it a notice requirement or an actual reporting requirement or an actual purchase requirement? Okay, if there's nothing else on that, we'll move on to the next item on the agenda, which is 2025-020. Which is a proposal to amend practice book section 2-38 and 2-47N in light of the decision in the Office of Chief Disciplinary Counselor versus Vaccaro. So this proposal is more of a urging from the Supreme Court in the opinion that we issued recently. From my perspective, as the author of that opinion, it looks like there's just a gap between 238 and 247, and that we just need to close that gap in one way or another. And that gap can be closed, I think, by just making it clear in 247 that if you're going to if you want to challenge something underlying the presentment, you have to file a 238 appeal. That language is missing, or there could be some more fulsome revisions of 238 and 247 regarding how such appeals are taken, and how these kind of public interest presentments are dealt with. And I don't know if Attorney Slack is still on.
Yes, Your Honor.
If you have any thoughts on this, or if you are interested in preparing a proposal in light of the decision in Vaccaro.
We could certainly put together a proposal if you'd like, Your Honor.
Okay. Everybody okay with that? We'll have, yes, I see everyone's fine with having you and Attorney Staines maybe work on a proposal and present it to us. And hopefully we can close this loophole. And as I said, it can be a really short proposal, or it can be a more fulsome if you look at it and say, hey, let's rationalize this a little bit more to make it a little clearer. But I know at least my colleagues would like to see us do that. So, all right. So we'll wait for the proposal from Chief Disciplinary Counsel on that. Lori?
Do you have a timeline? Is that going to be the next meeting or just when it's ready?
Well, I mean, ideally, since we have to have whatever we're going to have for the public hearing by March, if it can be done by February, that would be great. But you know, I don't know what else Attorney Slack and Attorney Staines have to do in their lives, and I don't want to impose something on them that's unreasonable. So to the extent you can get us something for February, great. If not, if you could at least maybe just submit a report and let us know kind of where it stands. I mean, I think our decision in Vaccaro kind of created a bridge until that happens. That certainly was the intention. Whether we were successful in providing that bridge, again, depends on who actually reads our decisions, I guess. And the attorneys who are subject to their third or fourth grievance may not be the people who are reading our decisions, but we can always hope. Okay. All right. That's the last item that we had on the agenda. Does anybody have anything else that they would like to raise? All right, seeing no takers, I'll entertain a motion to adjourn.
So moved.
Judge Armada, second.
Second.
Judge Doyle. All right, all those in favor? Aye.
All right.
Any opposed? No. Thank you all. We will see you at the February meeting.
Thank you.
Bye.
Bye, guys.